another eminent speaker from JSA, Mr. Sidharth Sethi. Mr. Sethi, when you talk about group insolvency, there are interdependence of assets amongst the entities which poses a significant challenge. And they're not only exclusive to India, it's a global concern. And we have seen Jet Airways, Justice Mukhopadhyay also made a mention of Netherlands administrative coming to India, and finally that agreement could be arrived at. Otherwise, there was a big tussle between the Indian RP and administrative of Netherlands. What are the emerging trends? Despite this, legislative reforms are also on the cards. So, what should be the strategy to manage those various stakeholders? I mean, could there be some proactive measures to be taken to enhance the transparency, efficiency, and the stakeholders' participation?
Thank you, Mr. Ganda. Esteemed speakers on the panel, Dr. Ashok Haldia, Mr. Madan, ladies and gentlemen, a very good afternoon to all of you. And I take this opportunity to wish all of you a very happy Baisakhi. The speakers this morning have set the stage for us to deliberate on some of the strategies which can be employed for managing group insolvencies more efficiently and effectively. And if I were to broadly look at these strategies, I would say the strategies can be categorized under two broad heads: procedural coordination and substantive consolidation. These are two expressions we heard from the other speakers this morning as well. Speaking of procedural coordination, as I see it, the below aspects will get covered in that. A joint application process for group insolvency mechanism, communication, cooperation, and information sharing between different insolvency professionals, courts, NCLTs, COCs, a single adjudicating authority to administer insolvency proceedings, a single insolvency professional to administer such proceedings, creation of a group COC and a group COC coordination committee, extension of overall time frame for conclusion of CRP of group entities, preferably to 420 days maybe, effective training and knowledge building measures, both for judges and various other stakeholders in the system, and utilization of internet-based technologies, which according to me can help in bridging the gap when the cases for all the group entities are going to be before the same forum. Digitizing processes such as filings and other procedural hearings, etc., can go a long way. So these are some of the measures which I would say come in procedural coordination. When we look at substantive consolidation, now this is a mechanism whereby the assets and liabilities of all the group entities are consolidated. So they are treated as part of a single insolvency estate for the purposes of reorganization and distribution. In one leading judgment of the Honorable National Company Law Appellate Tribunal in Giriraj Enterprises, the Honorable NCLAT has held that substantive consolidation is a possible means to maximize the value of assets. It is not necessarily an equitable principle, it is actually a legal principle. And this is done to ensure that there is value addition, to ensure that the ultimate objectives of the IBC are achieved, namely maximization of value of assets, and also implementation of commercial wisdom of the COC. Jurisdictions such as Australia and New Zealand have enacted provisions to guide courts as to the circumstances in which consolidations can be permitted and are allowed. For instance, in New Zealand, Courts can permit consolidation if they feel it is just and equitable. Speaking of Australia, pooling of assets is something which is permitted, and that is permitted in situations where the liquidator comes to a determination like that, and the unsecured creditors agree with that determination. So something similar can be looked at in our jurisdiction also. These are the broad strategies, and Mr. Ganda also asked me about what are the steps which can be taken to ensure that they are efficient for all stakeholders in the system. The first I would say is achieving effective communication, cooperation and information sharing. When we look at the ancestral legislative guide to insolvency law and the model law on enterprise group insolvency, they all recommend that insolvency professionals must cooperate with each other to the maximum extent possible. That's the expression they use. And they also say that they must cooperate with other stakeholders in the system. I would next say that development of a plan to ensure that there is proper coordination. It is also known as planning an insolvency or planning proceedings in some jurisdictions. And these are aimed at developing a insolvency solution, which could be in various forms. It could be a reorganization, it could be a sale on a going concern basis, it could be a sale of assets, or it could be a combination of liquidation and reorganization. And in the larger scheme of things, if we have to see that what we are discussing today and in the times to come, it achieves the objective, then we must have a group coordinator who can then do a group coordination proceeding and develop a group strategy which will be applicable and which will be followed by one and all.
Yeah, thank you, Sidharth. I'll come back to you after a while. Coming to now, Mr. Sethi, could you please, just tell us that what are the, unique challenges, which are faced by the stakeholders, and particularly the large group insolvency like Videocon and whatever cases, Lavasa or even that Radico Khatan's matter. What are the unique challenges which the IPs, particularly IPs or the creditors, would have faced?
Sure, sir. And to give that answer and to give some perspective, I totally subscribe to your view that we've actually come a long way. And what we all try to achieve here by these sessions and information sharing exercises is that we are trying to achieve greatest happiness of the greatest number, as Bantham says. And I think that's what the NCLTs and NCLATs are also trying to do. Now, when we look at the challenges, sir, and there are certain unique challenges which are faced by all the stakeholders, creditors, debtors, insolvency professionals. To start with, there are common and interdependent entities. Now, it is common for companies in a group to be dependent on each other for finances and operations. So if one were to separate the ownership of assets and liabilities of those group companies, the insolvency process can become cumbersome, inefficient, costly and complex. Then there is the issue of solvent entities being dragged into the insolvency process. We saw that in case of Videocon. And Mr. Lal here will remember that KL Limited was one company which was self-reliant, financially doing very well. And then there was a request to also include it in the entire rigmarole. But then the courts kept it out of the union, and rightly so, because it was autonomously equipped to be financially viable. Then the other issue that I see is coordination when it comes to multinational conglomerates, and there are two aspects to it. There are coordination problems when it comes to dealing with foreign representatives, and taking custody and control of assets in other jurisdictions also becomes an issue, especially in the absence of a mechanism for cross-border insolvency. Related to this is another aspect where the insolvency professionals, the RPs, etc., face a challenge when they're dealing with foreign representatives and for consolidating claims, which becomes a Herculean task because there are various lenders which are involved, there are different loan profiles, different security interests, and as such, there is a need to take assistance from other professionals who then assist the RPs in their functions. The working group that we had has given a definition of the corporate group, which in my personal view, I feel is somewhat vague, simply saying that holding companies, subsidiary companies, etc. will all form part of the corporate group. I believe that this is too vague to be kept like that. And therefore, if we have to address these issues, first and foremost, we need to come up and arrive at a more concrete definition of corporate group. In State Bank of India versus Videocon, certain parameters were laid down, and those are instructive and they throw good light on what all aspects can be considered, and I'll just list out a few of them for everybody's convenience. Common control, common assets, common directors, common liabilities, interdependence, interlacing of finances, intricate link of subsidiaries, interlooping of debts, intertwined accounts, pooling of resources, and coexistence for survival. So these are some of the aspects which were laid down, parameters which were laid down in that matter. The framework for group insolvency should not apply to solvent entities unless solvent entities volunteer to be a part of that, like we have in the UK, or such inclusion is likely to lead to better returns for all the lenders, or that the entity is likely to be insolvent in the near future. Otherwise, as I see it, solvent entities should be kept out of it. And in case of interlinked and interdependent entities, I am all for coordination, I'm all for consolidation, because that helps in information sharing, that helps in reduction of administrative costs, and in the larger scheme of things, it really goes a long way in achieving the ultimate objective of the Insolvency and Bankruptcy Code. And costs for group insolvency have also been a matter of some concern. They must be included in CIRP costs, which shall and which must be paid by all the participating members. So those are few thoughts which I had, sir, on this.
Yeah, thank you, Sidharth.
So, I'll answer the question posed by the gentleman sitting here. And you're right. If you ask me whether the draft, which is now available for public scrutiny and for scrutiny by professionals like us, is it foolproof? No. But that is true for most legislations. When the legislature drafts something and a parent act is drafted, there are scenarios and possibilities which can't possibly be visualized by the draftsman, and therefore the need to have rules and regulations. And there is a provision in every statute that the executive can come up with rules and regulations. And idea is to plug loopholes. We saw that with the Arbitration and Conciliation Act also. We had the 1940 Act, and when the 1996 Act replaced the 1940 Act, today if you see the judgments interpreting, let's say, a simple provision as simple as Section 11, which is dealing with appointment of arbitrators, and the way courts have interpreted that provision in the last 15 years, and at least in the last 18 years that I have been in the profession, every time there is a process of learning, unlearning. The same thing we've seen with the Specific Relief Act. So yes, it's not foolproof, and as we go along, but it's a step in the right direction. As we go along, as the processes involve, when the situations emerge, I am sure our judiciary is vibrant enough to plug those loopholes, to provide those explanations and answers wherever the need so arises. But it's a step in the right direction, and I think that's a very happy situation to be in.